Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications from new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court took serious exception to hate speeches, saying that these will end the moment politics and religions are separated and politicians stop using religion in politics. Terming the hate speeches as a vicious circle, the top court said that these utterings are being made by fringe elements and people should restrain themselves from doing so. A bench of Justice K.M. Joseph and Justice B.V. Nagarathna referred to speeches of former Prime Minister Jawaharlal Nehru, Atal Bihari Vajpayee, saying people from remote area and every nook and corner used to gather to hear them. Wondering as to how many people can courts initiate contempt action against, the bench said why cannot the people of India take and pledge to not vilify other citizens or communities. We are hearing the contempt petitions because states are not taking action in time. This is because the state has become impotent, powerless and does not act in time. Why should we have a state at all if it is silent? The court asked. Observing that merely registering complaints is not going to solve the problem of the hate speeches, it reminded the centre to need to take the action against persons making such statements. The Supreme Court has held that the Affinity test is not a litmus test to decide a caste claim, as neither it is an essential part of the process in every case, nor it is the sole deciding factor. A three-judge bench of Justice S.K. Kaul, Justice A.S. Oka and Justice Manoj Mishra, while noting that the affinity test cannot be conclusive either by way, observed it is not the integral to the determination of caste status made by the Caste Scrutiny Committee. When an affinity test is conducted, the Vigilance Cell, the result of the test along with all material on record having probative value will have to be taken into consideration by the Scrutiny Committee for deciding the caste validity claim it asserted. The larger bench was deciding the issue referred by the division bench of Justice Hemant Gupta and Justice V. Subramanian, as it is noted that two decisions of the apex court in the matter stand on different footings. The court affirmed the decision in Anand versus Committee for Scrutiny and Verification of Tribe Claims and others and discarded the findings of Vijay Kumar versus State of Maharashtra and others. The Supreme Court has decided to examine whether an accused can approach court through power of attorney for quashing of proceedings against him in a criminal case if he is not able to be physically present to pursue the case. A bench of Justice Krishna Murari and Justice Sanjay Karol issued notice on a plea of Britain-based non-resident Indian to allow his petition filed through power of attorney given to his brother for quashing of criminal proceedings against him on complaint filed by his wife in dowry harassment case. His counsel submitted that in matrimonial disputes where husband or in-laws are living abroad and they are not evading the process of law, they should be permitted to file quashing petitions under Section 482 CRPC through their family members or friends or on the basis of power of attorney. Challenging Madhya Pradesh High Court order which rejected the petition filed through power of attorney, saying the plea was not maintainable, the petition said that right to access to legal justice or to avail legal remedy in the proceedings where personal appearances of the petitioners is not required or to have been permitted to file petitions under Section 482 CRPC through his family members, especially where petitioners is not absconding and he is reasonable in ability to present in India simply for the purpose of filing. The Supreme Court is inclined to examine the issue of whether a family temple can be dedicated to the general public without following any religious rituals, practice and customs, as the petition in this regard has been filed. The petitioner, a committee constituted under the board to manage the affairs of the Thirukhelapuram Sri Krishna Swami Temple, has challenged the Kerala High Court effectively granting the rights and title of a temple to a party in an injunction suit. It is their contention that the High Court erroneously framed the issue at the stage of a second appeal, as there is absence of prayers or pleading on behalf of the respondent qua title and possession over the scheduled property. Submitting that the title and possession of the temple were given to them by a municipal court in 1989, they have argued that the High Court cannot therefore adjudicate on the title and possession which has already been attained finality. The Supreme Court Division Bench of Justice M.R. Shah and Justice Krishna Murari was left bewildered after appellant's advocate demanded the withdrawal of appeal mid-pronouncement of the judgment. Expressing displeasure over the move, the bench called it a mockery of justice. Calling the incident as unimaginable, the court told the advocate that the same is not permissible. The whole instance left the bench upset and wondering that the standards of the Supreme Court are going down. Next we have Delhi High Court. The Delhi High Court Division Bench has asked the Google attorney to consider issuing a lighter warning for downloading the Winzo app from the website by April 26th. According to the US-based tech company, other web browsers also show this warning when users download the third-party APK format files or programs to shield users from potential viruses. As a result, the same is considered as an industry standard. Winzo disagreed with the Google statement, claiming that the Google had not checked to see if their program include malware. According to Winzo, 42% of the consumer chooses not to download their app due to Google's cautionary notice. Previously, the company challenged the order of a single judge, Justice Amit Bansal, who noted that the warning does not prohibit users from downloading the Winzo app and users can still choose to continue downloading. After asking Dhruv Rathee to retract the portion that prima facie dispatched Dabur's real juice, the Calcutta High Court has now ordered YouTube and other social media platforms to take down or block access to the YouTuber's video on health effects of packaged fruit juices. Justice Ravi Krishna Kapoor noted that the directions issued in the previous order has not been complied with till date. It is the plain and unqualified obligation of any person against or in respect of whom an order is made by the court to obey the same unless and until the order has been set aside, modified or varied. The uncompromising nature of the obligation is fundamental to the rule of law, the court added. Dabur has filed the present suit claiming that the YouTubers specifically dispatched their product Real Juice. In the suit for protection of the intellectual property rights filed, the company has contended that the impugned video is specifically aimed at degenerating and discharging packaged fruit products. The grievance of the company is that the impugned video makes a fair comparison between carbonated soft drinks and RTS fruit beverages, and moreover there is an unfair comparison made between the fresh fruit juices and RTS fruit beverages. The Delhi High Court has set aside trial court's discharge of Sharjeel Imam, Safura Zargar, Asif Iqbal Tanha and 6 others in the Jamia Violence Case of 2019 while charging them under rioting, unlawful assembly and other offences. Justice Swarna Kanta Sharma in her judgment said that the prima facie, as seen in videos, the accused were in the first line of the mob and they were raising slogans of Delhi Police Murdabad, adding that they consciously choose to be part of the unlawful assembly. The court said that the accused were carrying dandas in their hands and climbed the barricades to march towards parliament despite several warnings by the police. The judge, however, discharged the accused of some of the sections. Rash and negligent driving does not necessarily mean excessive speed and will include not taking due care while driving, particularly overtaking either a stationary or moving vehicle, the Delhi High Court has said. The court's observation came on a petition filed by a family of a motorcycle rider who died after colliding with the DTC bus parked in the middle of the road without any signal or light indicator. The Motor Accident Claims Tribunal had granted more than over Rs 17 lakh to the family but ordered a reduction of 20% towards the contributory negligence by the deceased. Now let's have an overview of other high courts. In a notable ruling, the Bombay High Court has established that the Registrar General of the court has no power to order for mass dismissal of cases for non-removal of objections. The single judge bench of Justice Riaz Chagla in this view recalled the Portho Notary and Senior Master's September 15, 2022 notice dismissing civil suits filed before December 2021 in default for non-removal of office objections within 8 weeks. Restoring the dismissed suits to the High Court's records, the court opined that the impugned are clearly contrary to Rule 986 of the Bombay High Court, OS Rules 1980, as the common notice was issued without listing of the matters. The division bench of Himachal Pradesh High Court has noted that the state was being discriminatory while denying a 4-tier pay scale to the veterinary officer on the basis that they deal with animals, while the MBBS doctors under the Health and Family Welfare Department, who are at the same position, deal with humans. The court concluded that in the current case, as well as veterinary officers cannot claim to be denied a grant of a 4-tier pay scale on the ground that they deal with animals. The court further observed that the state had discriminated against the veterinary officers appointed on a contract basis on the lines of Article 14, thereby leading to a gross violation of the principle of equality. The Allahabad High Court, while dismissing the application seeking quashing of the charge registered case under Section 358 of the Uttar Pradesh Prevention of Cow Slaughter Act 1955, opined that the central government should ban cow slaughter and declare cow as a protected national animal. The court observed that we are living in a secular country and must have respect for all the religions, and in Hinduism the belief and faith is that the cow is representative of divine and natural beneficence and should therefore be protected and venerated. It thus hoped and trusted that the central government may take an appropriate decision to ban cow slaughter in the country and to declare the same as a protected national animal. The Madras High Court, while adjudicating upon a property dispute, held that giving valuable articles as Stridhan to the woman during her marriage does not mean that later she cannot claim her right in the ancestral properties. Stridhan was held to be separate and it was distinguished from a release deed. The court rejected the contention of the appellant with regard to the decision in Leelavati versus Chillaswamy 2023 and observed that the ratio would not apply to the facts of the present case, since in that case a release deed was executed. Lastly, the bench observed that the first appellant court had erroneously held that since the daughter were given in marriage by giving Stridhan, they cannot claim any right over the suit properties. The Punjab and Haryana High Court, in a first in Indian judiciary, has used artificial intelligence chatbot ChatGPT in deciding a bail case. The single judge bench of Justice Anup Chitkara stated that he used the software to aid him in assessing the worldwide view on bail when the assault was laced with cruelty, as it has been trained with multitudinous data. He clarified that any reference to ChatGPT and any observation is neither an expression of opinion on the merits of the case or nor shall the trial court advert to these comments. The reference is only intended to be present a broader picture on bail jurisprudence, while cruelty is a factor, he said. Moving on to miscellaneous news. Following the disqualification of Rahul Gandhi as an MP, a plea has been moved in the Supreme Court challenging the validity of provisions mandating blanket and automatic disqualification of legislators upon conviction and sentence, irrespective of the nature, gravity, and seriousness of the offences. A social activist has prayed that automatic disqualification under Section 8(3) of the Representative of People's Act should be declared as ultra vires of the Constitution for being arbitrary, illegal, and violative of the fundamental rights to equality. It was also contended that the mandate of Section 499 defamation of IPC or any other offence prescribing maximum punishment of 2 years will not automatically disqualify any sitting member of the legislative body, since it violated the freedom of speech and expression of an elected representative. The petition contended factors such as nature, gravity, role, and moral turpitude and the role of the accused ought to be examined while considering disqualification under Chapter 3 of the 1951 Act. The Bombay Lawyers Association has moved to the Supreme Court against a High Court decision dismissing the PIL against Union Law Minister Kiran Rijiju and Vice President Jagdeep Dhankad for their remarks on judiciary and the collegium system for appointment of judges. The Bombay Lawyers Association has claimed that Mr. Rijiju and Mr. Dhankad showed lack of faith in the Constitution with their remarks and conduct. It had sought that orders to restrain Mr. Dhankad from discharging duty as the Vice President and Mr. Rijiju from discharging his duty as the Cabinet Minister for the central government. The PIL had claimed that the frontal attack not just on judiciary but on the Constitution by the two executive officials has lowered the prestige of the Supreme Court in public. The Madras High Court has directed the Tamil Nadu government to frame appropriate guidelines for strict compliance of the rule prohibiting the arrest of women after sunset and before sunrise. Justice Anita Sumant made it clear that the bar under Section 46(4) of the CRPC should be followed even in exceptional, urgent, and emergent situations. The proviso imposes a bar on arresting women after sunset and before sunrise except in exceptional situations. It also mandates presence of a woman police officer during the arrest, for which prior permission should be obtained from the jurisdictional judicial magistrate. The central government favours a uniform civil code in the country, but its enactment is within Parliament's domain and not courts. The Solicitor General Tushar Mehta has informed the Supreme Court. The three-judge bench of CJI D.Y. Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardiwala, which was adjudicating upon a petition filed by BJP leader and advocates Ashwini Kumar Upadhyay, agreed with this SG's submission and asserted that it is not inclined to entertain the petitions under Article 32. Stating that entertaining the petitions would mean directing the enactment of law, the CJI explained that a writ of mandamus cannot be issued to Parliament to enact a law. The Allahabad High Court has sought centre and state government's reply as to how the government expenses or the funding provided by the government exchequer religious education be imparted and whether this could be in violation of Article 14, 25, 26, 29 and 30 of the Constitution of India. The court was adjudicating on petition filed by a teacher of a madrasa pertaining to some salary disputes seeking various reliefs, noting that in madrasas besides normal curriculum, the religious education is also imparted. The court sought a response from the authorities within 6 weeks. In the end, we have international news. Malaysia's top court has dismissed a bid by jailed former Prime Minister Najib Razak to review his corruption conviction over the multi-billion-dollar scandal at State Fund 1MDB, ending Najib's judicial efforts to challenge the guilty verdict. Najib was jailed last year after Malaysia's federal court upheld a guilty verdict and 12-year prison sentence handed down to him by a lower court. A court in Pakistan's eastern city of Lahore has struck down a colonial-era sedition law, calling it inconsistent with the constitution in a verdict hailed by free speech advocates and journalists. A single judge bench of Lahore High Court has declared the sedition law unconstitutional. The court's verdict will be applicable across the country unless the Supreme Court overturns the High Court's decision. The ruling from Justice Shahid Karim came in response to several similar petitions filed against the law by citizens on the ground that the government uses it against its political opponents. A year-long probe into a hush money scheme involving former President Donald Trump and adult star Stormy Daniels has led to him being indicted by a Manhattan grand jury for his alleged role in the scheme. At issue in the investigation is the payment made to Daniels and Trump's organization's reimbursement to Cohen. According to court filings in Cohen's own federal prosecution, Trump Organization executives authorized payment to him totaling to cover his original payment and tax liabilities and rewarded him with a bonus. The Manhattan DA's investigation was hung over Trump's since his presidency and is just one of the several probes the former president is facing as he makes the third bid for the White House. The United Nations General Assembly has adopted a resolution proposed by the South Pacific island nation of Vanuatu to seek an opinion from the International Court of Justice on what legal obligation nations are under to protect climate systems and people affected by climate change. Co-sponsored by 132 countries at the UN, the resolution was adopted by a consensus. The UN is now empowered to seek the ICJ's opinion on what countries' legal obligations are to protect the current and future generations from climate change. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.